Good morning, everyone. This is Judge McBurney. It looks like we're having a virtual hearing today. We'll figure out who all is here and ready to go in just 1 second. All right, so this is 24CV003909. It is Freedom Lofts Condominium Association versus the Powells. And what we're working through today, I believe, is a motion for summary judgment that Mr. Conroy has filed on behalf of the COA that obviously the Powells oppose. There's a second dimension to this case that doesn't seem to have been developed all that much. In that the Powells brought some counterclaims against the HOA, and then there was an effort to bring in a roofing contractor. I don't see a lot of activity in that space, but Drew Eckel, the firm, was brought in to represent the HOA as to the counterclaims. We're not dealing with those today. We can talk about them in the abstract, but my understanding is that the motion for summary judgment is not targeted at the counterclaims. It is simply Freedom Loft saying the annual assessment or the monthly fees weren't paid, and we're entitled to get them, and we are entitled by way of summary judgment to get what we, the COA, sought in our original complaint. However that's resolved will not resolve the counterclaims. They will remain outstanding. Is that a fair summary, Mr. Conroy?
Yes, Your Honor. Excuse me. Yes, Your Honor. Absolutely. I think that is that is 100% accurate.
Okay. And you're on for Freedom Lofts. Who is on for the Powells?
Good morning, Judge. This is Pete Brogdon. I believe my appearance was entered yesterday. And am I muted? I'm not muted.
No, I can hear you. Well, that's welcome aboard. I had different lawyers. Are you associated with the other lawyers, or are you replacing the other lawyers?
I don't know who counsel of record is previously, but Mr. Powell is an attorney. I'm not sure if he was pro se. I know he may have had someone else that may have entered their appearance, but I am separate and apart from any other lawyer that has previously been counsel of record for the defendants.
Got it. Well, welcome aboard. It's good to have you. I'm going to give you those names. I think it's Hakeem Brock and Brandon Randall, but I'm getting into the docket now, and we will move forward. It probably hasn't hit the docket yet. I'm not doubting you at all, Mr. Brogdon, that you filed an entry. The last item in the docket was from the 17th, some certificates of service and whatnot. I think that's all from plaintiff. But if we go to answer.
And I'm checking with Mr. Brock's office because I'm going to substitute in. It looks like the EOA was filed last night, and there may have been another notice of filing that was filed last night.
Okay. You know Mr. Brock?
I do.
Okay, great. So we had a substitution of counsel. in July, but let's see what that is. That's Drew Eckel getting in the mix, and that is Ms. Meckie. Hello, Ms. Meckie.
Good morning. Good to see you, Judge.
Good to see you. You are observing just in case we veer into counterclaims?
Exactly.
Okay. Okay. Well, like I said, Mr. Brogdon, we're good to go. If you are here and Mr. Brock's not, and you're saying you're the Powells lawyer, that's who's going to handle things for the Powells. And we'll move on. And I'm confident at some point today, the docket will show what you filed last night. The clerk doesn't have instantaneous turnaround time, so it'll hit the docket. I think you said you filed two things. What else did you file?
So I've only filed the EOA. I believe Mr. Brock and his office may have filed a notice of filing, and that is just for the record.
Okay, got it. Well, as I understand it, then, well, you heard what I said, Mr. Brogdon. We are here to work through plaintiff's motion for summary judgment on their claims in the complaint. Did you have a similar understanding of what the purpose of today's hearing is?
Yes, Your Honor. And Judge, I would tend to agree with that the only issue here is plaintiff's motion for summary judgment. I think that the counterclaims and the notice of non-party fault of themselves kind of bleed into part of our argument that there was a genuine issue of material fact. But I agree with the way that you've put that forward as to the issue to be decided or the issue to be heard today.
Okay, great. Then, Mr. Conroy, I'm ready when you're ready.
Great. Thank you, Your Honor, and thank you for allowing the parties to appear virtually. I currently reside in Indiana, so that is of great benefit to me and my family, so thank you. Your Honor, just a little bit of background as to the procedure of the present hearing where we are today. There's an original motion for summary judgment filed in February 2025. Defense filed a response. It appears to be a timely response. And then given there's some time between the motion and when the hearing will be scheduled, our office filed an amendment to that MSJ just as to the amounts because additional amounts had become due.
Okay.
Your Honor, it appears that there's no.
So I'm sorry, I'm going to interrupt just because this may target things. I'm pretty familiar with HOA and COA cases and the obligations that owners or members have to pay the assessments. It seems like the Powells have not, and there doesn't seem to be a dispute about their failure to pay. It seems like their pushback is either the contract is breached because of this roof damage or the faulty roof and the damage caused by the water intrusion, or they're able to withhold until the COA fixes it because it was the COA's vendor that caused the damage to the roof with the nails going through the ceiling and the water intrusion, et cetera. So I think that's the issue. I'll hear from Mr. Brogdon at the appropriate time, but I haven't read anywhere that anyone is saying those are the wrong amounts or we wouldn't in ordinary circumstances owe them. But lo, these are not ordinary circumstances because COA, you hired, I guess it's Crabapple Roofing, and they punched a bunch of holes in our roof and it made our place uninhabitable. Because of that, legally, there is no obligation for us to pay our assessments. Now, admittedly, that is relying on some aged cases, older even than I, and they aren't HOA or COA cases, but I understand the legal principle that really the COA has some part of its contract, I guess, in the form of the declarations, this obligation not to do bad work on the roof so that the place is made uninhabitable. So I don't mean to tell you how to make your own presentation, but I'm with you that there is an amount that wasn't paid and there are very clear statutory obligations and contractual ones by way of the declaration to make those payments. But then we've got this wrinkle in this particular set of facts.
Yes, Your Honor, happy just to get to the main, what appears to be contention in this matter, which is whether or not the association can seek these amounts in light of alleged breaches of covenants as to alleged asserted association responsibilities concerning this maintenance issue. Long story short, I do believe I agree with the court that um, the case law that's being relied upon by opposing counsel is aged and is not specific to condominium association law, and that those cases you need to look to the 1990s for I think more applicable case law as well as statutory authority concerning this sort of situation. Specifically, as briefed, there's OCGA 44380, which talks about at Part D1 that it says the declarant shall pay for all common expenses until the first common expense assessment is due from any unit owner. And then the important part here is thereafter, no unit owner other than the association shall be exempted from any liability for any assessment under this code section or under any condominium instrument for any reason whatsoever, including without limitation abandonment, non-use, or waiver of the use of or enjoyment of his or her unit or any part of the common elements. This has been interpreted in a case from 1992. This is Forest Villa Condominium versus Camaro. In that matter, which had some similar facts as the present matter, where there is a lawsuit filed in it for a condominium association seeking unpaid assessments. The defendants brought counterclaims. One of the counterclaims including a failure to maintain and make repairs. And then the question was, can the association move forward? And the association filed a motion for summary judgment seeking the unpaid assessments and related charges. That court reviewed and interpreted OCJ 44380D, the same section I just referenced, the same section in my brief. And they found, I'm just going to read the language because I think it's incredibly important to this present case. There's no legal justification for a condominium owner to fail to pay valid condominium assessments. This reflects a clear choice by the legislature that the owner's obligation to pay assessments be absolute, and the condominium unit owner involved in a dispute with the condominium association about its services and operations may not exert leverage in that controversy by withholding payment, but must seek other remedy. The obligation to pay assessments is independent of the association's obligation to provide services. This is necessary because the communal business of the condominium association for the benefit in common of all condominium owners continues unabated during pendency of any such individual dispute. The Court of Appeals went ahead and found that the plaintiff was in fact entitled to summary judgment on liability for unpaid assessments. There are subsequent cases.
Can you give me the citation to that case? You gave me the name, but it was long and complicated.
Absolutely. Yes, Your Honor. It is, let's see, 205 GA APP 617.
Okay. All right. And so that was sort of the earliest case you found that says 44380D means what it says, which is no exemption. And it gets us to really where I was going to press Mr. Brogdon, which is sure, the Powells may have a compelling claim, but in the end, that just seems like it's a recoupment type claim, and that the Powells owe this amount and they're going to need to pay it, and there's going to be a judgment against them in that amount. But if they are successful with their counterclaims, when one does the math, it may be that in the end, the COA is paying the Powells. But in the interim, they remain obligated to pay the monthly assessments for the very policy reason that that case mentions, which is the assessments aren't just, hey, we're sticking it to you, but they go into a common pot so that the association can keep the pool clean and the security gate closed and locked and all that. And if I could withhold mine because I'm sour with what the COA did to my front door, then it's harder for the community to pay for all the common elements and their upkeep.
That is my understanding. And there's been subsequent cases. Again, largely this matter was settled through case law from the 90s, though there was a more recent case. I don't want to just rattle off a number of cases, but just for example, there's a case in 97, Dunhill, Condo versus Gregory. And then there's another case the next year, Atlanta, Georgetown, Condo versus Chaplin. These cases are essentially just citing the prior case and explaining more or less, and that there's no legal justification to fail to pay valid assessments. And of course, they tie in the Forest Villa case in different manners, but it essentially boils down to that issue. There was a more recent case, and this one I'll go ahead and just cite. It's North Lake Manor Condo Association versus Harvest Assets. This is a 2018 case. This is case number, let's see, we've got 812 Southeastern 2nd 658. 2018 case. And again, it cites Forest Villa, just talking about that, again, based on the plain language of statutory subsection, we've held that there's no legal justification for a condominium owner to fail to pay valid condominium assessments, and that the public policy expressed in the statute assures the fulfillment of obligations and functioning of a condominium association as a whole not be jeopardized or compromised by individual disputes, which may or may not be meritorious. And so I think that's the situation here, is that we're here just as the collection case. It's a separate covenant, the obligation to pay assessments, from the asserted violation of other covenants concerning the association's maintenance responsibilities. But just whether or not it's a meritorious counterclaim, it should not jeopardize the obligation to pay assessments and subsequent potential harm to the community with withholding payment. As the judge pointed out, my understanding is there's no such thing as, you can't do a set off when it comes to, because these are separate obligations. But that being said, from a practical standpoint, we're just saying that the owners, for the collection case, they owe money and related charges for failure to pay those assessments timely, and all the work that's been involved up to today to try to collect that debt. They may or may not be successful in their claims, but that's a separate covenant and a separate matter. And so I believe we can resolve the issues as to the obligation to pay assessments and the related charges that have become due since then, and the association's ability to foreclose its statutory lien. That it can all be resolved now, and then the separate issue can be tried at a future date.
Okay. No, I don't disagree with the way you are describing the structure of it. When I said set off, I didn't mean specifically that the COA would be obligated to reduce what it's trying to collect. I just think writ large, if in the end Mr. Brogdon establishes liability on the COA's part for some of these damages, then it may well be that the total bill here is reduced, meaning in the end, don't give us $100,000 and then we're giving you $80,000 back. Just give us $20,000. The wrinkle is that we've got this crabapple roofing contractors, and so it may be that in the end it's crabapple who is paying the Powell something. Who knows? And we're not sorting that out today. And I don't mean to suggest that there's a reason to withhold judgment on your motion because there is this pending potential liability for either your client, as represented by Drew Eckel, or by Crabapple. I just was noting that in the end, it may be that there's money owed on both sides, and rather than both sides cutting a check, someone just cuts a smaller check than they would have otherwise. But we'll see. It may be that your part moves fast enough, and the Powells don't want to have the place foreclosed on, although it sounds like they're not necessarily living in it anyway, that they make the COA whole, consistent with the judgment, while they continue to pursue their counterclaim. We'll just see how that rolls.
Yes, Your Honor.
Okay. Mr. Brogdon, I'm going to turn to you, and I didn't mean to cut Mr. Conroy short. If in the end, Mr. Brogdon, you think some of the dollar figures are erroneous, and that's a reason to not grant summary judgment, I'll certainly pivot back to Mr. Conroy so he can present other parts. But to me, the issue as I read the briefs wasn't the amount of the monthly assessment or anything like that. And sometimes there's a homeowner who says, I think the fee is unreasonable. All I did was not paint my mailbox and they're hitting me $100 a day. That's not this case. It seemed like the Powell's main argument was, well, wait, we've had issues with this place and someone needs to be on the hook for the harm and damages it has caused us. And one approach was, well, that's the COA. And so that's a reason not to grant summary judgment. So I'm going to turn it over to you, and you make the argument you want.
Thank you, Judge. And I would like to piggyback off of Mr. Conroy, and I appreciate the court allowing us to appear via Zoom. I'm actually back home in West Virginia for the holiday, so I appreciate that, Your Honor.
Right, this is a very diverse. We got Indiana, West Virginia. Ms. Mecki, are you in Atlanta or are you in New Mexico?
I'm in Atlanta.
All right, go Drew Eckel. Appreciate the home lawyering. All right, what's happening in West Virginia, Mr. Brogdon? What do you want to tell us?
I'm originally from here, and I wanted to say that to start this off, I think it's a tiny bit more nuanced. I don't think that there is a party here that would disagree with the fact that the Powells, namely Mr. Michael Powell, he actually currently resides in the unit. He's lived there throughout this whole ordeal with this water intrusion since late 2020, and then I believe it's been remedied or potentially been remedied here in April of 2025. I don't think there's a disagreement or an argument to be made that there is a certain amount of assessments that are rightfully owed to the homeowners association. The issue arises when the homeowners association is asserting that they are owed collection fees, they're owed attorney's fees, and they're owed any dollar amount that they have used in trying to collect on, I believe it's like $17,000 potentially in assessment fees that are previously owed. And I think it's an important point to note for the record, Judge, that in 2020, I believe Mr. Powell gave them notice that this water intrusion had occurred. He paid his assessment fees. And then at a certain point in 2021, he stopped paying his assessment fees, giving the homeowners association explicit notice. Hey, this is an issue and it's not been fixed. I've given you timely and proper notice and nothing's happened. So I'm not going to pay. So it wasn't like he stiffed them. Now, again, he has an obligation. It's statutory. We're not arguing that he doesn't have that. That would be disingenuous. But at certain point, Mr. Powell stops paying the homeowners association. Then in 2023, he says, you know what? This has gone on long enough. And in recognizing that I have a duty, I want to come back and I want to make payment to the homeowners association. In 2023, the homeowners association refused to negotiate and it refused to accept the payment that Mr. Powell wanted to remit. And so there was no way for him to pay unless he paid in full. They would not take partial payments. And then at a certain point in time, the homeowners association, it seems based off of my review of the record, which is very brief, that the homeowners association changes the way that they took payment or who they were using to process payment or something of the like. And Mr. Powell was able to make his annual assessment payments. And he's continued to do such all the way up until today. And so the real issue is not with the past due amount of the assessments that were missing from that period in 2021 or 2022 and 2023. It's the unjust enrichment because they have unclean hands, right? They've not fixed this, and then they would mark it complete through whatever app or whatever platform it was. And he had to keep coming back saying, hey, the water is still intruding. All along that time, he was paying his annual assessments. And so their collection of attorney's fees or collection fees or anything associated with their collection action, and that's, I believe, is that law, anything associated with that, we would argue, Judge, that a jury needs to decide the reasonableness of those charges, right? That's the argument. So the 17,000, if that's the number amount, now I'm sorry if it escapes me, of the past assessments, there's no disagreement. And I would submit to this court that Mr. Powell had been holding the money in a separate savings account, and he's ready to remit payment for those past assessments. He's ready to do such. The issue is trying to add, the icing on the cake because there was bad action on both sides, and now they're saying, hey, we had to try to collect on this. And I think that is one of the issues. And the second is the foreclosure. I'm sorry, I don't know if is that me?
Is what you.
I hear some feedback.
I do as well. It's like a murmuring.
Really? Okay, we're not hearing it on this end. Sorry about that.
No, it's fine. It just stopped.
Let me see if there's anyone. No, there was no one else who's on. It's just the three of us whose mics are on.
Yes, sir. And I apologize, Judge, for that. And the last thing is at equity, right? The foreclosing of the unit. Again, to decide that on summary judgment, I think is, how would I say it? It's inequitable, right? Because there are facts in the record, specifically what was produced in discovery. I believe that all of it has been filed. And I understand that this court is obliged to search the entire record before issuing a ruling on summary judgment. I know there may be issues with timeliness of things coming into the record before the hearing. And I think that's something that can be dealt with. But to foreclose on the unit when, as Mr. Powell had lived in this unit, it was not habitable for some time. who's been living with mold, who's been living with water intrusion. There is action on behalf of the homeowners association that should preclude them in equity from foreclosing on the unit. I think the real issue is, and maybe I can talk to Mr. Conroy after that, is if they're willing to accept the past assessments, we can deal with that. But as it relates to the attorney's fees, any of the other collection fees, anything that's trying to be recovered or recouped, which we would believe would be unjustly, um, we have issue, and we believe that there's a jury question as it relates to the reasonableness. This isn't a situation where it's a sanction for attorney's fees, and a hearing must be had for attorney's fees. But if they're arguing that there's some contractual claim that they are to be awarded for trying to collect, I believe the case law, and I'd have to cite this for you, and I may be able to provide it here shortly, Judge, is that the reasonableness is a jury question. And so, to make it very concise, I believe Mr. Powell and Miss Powell, his mother, they're not disputing the fact that there are past assessments owed. There is a dispute as to the reasonableness of any other fees that are trying to be collected based off of the conduct of the parties. And to wrap it up, foreclosing in an equitable remedy is just not equitable. It's inequitable because there are unclean hands here, and there are defenses to that, which must be parsed out, and ultimately a jury would have to decide. And so, with that, Your Honor, I will take any questions, or I will hand this back to Mr. Conroy.
We'll probably have a back and forth because I do want to hear from Mr. Conroy a bit about the amounts owed. While you were making your presentation, Mr. Brogdon, you triggered a couple things in my mind about, well, what are the late fees? Have there been penalties, fines, things like that? I don't think there have been fines. I think there may have been fees. And when I say fees, a late fee, which would be, I think, I'm going to find out from Mr. Conroy, all part of the contract. You owe $200 a month. If you don't pay by date X, then it's $10 each month you haven't paid it, or whatever it is. But I am going to want Mr. Conroy to walk us through the ledger. And then I also need to understand the basis for the attorney's fees. By that, I don't mean, are your rates reasonable? I saw the dollar amounts. They look very reasonable. But the basis to collect those attorney's fees, because I have learned many times from the Court of Appeals, there's no summary judgment for 13611. That is 100% for the fact finder, be it a judge at a bench trial or a jury at a jury trial. But in looking at your complaint, you don't invoke 13611. And so it may well be it's part of the covenants and the declaration that the COA gets to collect reasonable attorney's fees if it has to pursue a unit owner who is delinquent on his fees. So I'm going to ask you, Mr. Conroy, to walk us through the ledger a little bit so I can see what the dollar amounts are that are owed. And then if you could address the attorney's fees question as well.
Absolutely. Thank you, Your Honor. If I may share my screen.
Sure.
So I think probably the best document to look at is the most recent affidavit for cost of collections affidavit, which was filed. I'm sorry, this is the most recent one, but I was going to do the one that was from earlier. One moment, please. Okay, great. There's one that we very recently filed, but it was just filed the other day. I don't want to feel like I'm surprising anyone. So this is one from October 3rd, 2025. It was filed along with the amendment to the MSJ. The affidavit of cost and collections it's a document that's prepared by a company called Alliance CAS. They did both litigation debt collection work, and they also perform an accounting function when it matters in litigation to act as a way to aggregate all the amounts owed.
Okay.
And that's done in the form of a statement of account.
Can you make that document? There we go. Thank you.
Yes, Your Honor. So the statement of account is Exhibit A, and it shows on page 1 kind of a breakdown of the individual charges. So you can see here through September 23rd, 2025, $17,000 in assessments.
So that's the figure I think Mr. Brogdon was alluding to. I heard him say 17,000. So those are just the monthly assessments that have not been paid.
Correct, Your Honor. And it's important to note there have been some payments, and I'll go into detail about when those payments started, when they stopped, when they started back up. And some of those payments would be applied to various amounts. So the payments aren't going to necessarily just all go to assessments if there are additional amounts being incurred as well. They do not go to attorney's fees. That's important to point out because there was a case decision, I think it was either earlier this year or last year. It's a recent case that said that because there is a reasonableness standard for attorney's fees specifically, and the code section that we're referring to or rely on when it comes to attorney's fees is 24CV0039. It provides for collection of reasonable attorney's fees actually incurred. There's a case that was decided that you can't apply payments during litigation to the attorney's fees because there is a reasonableness determination. And so these amounts, you'll see later on that there was one payment that was sent to our office that we actually returned back so it could be applied to something else. But anyways,
Okay.
but that $1,700 might have been reduced a little bit by voluntary payments, but it'd also be paying down these other amounts except for the attorney's fees.
Okay. And interest is just collecting on the principal, if you will, that's past due. So the 17,000, I understand that number may have fluctuated as Mr. Powell was making some payments. Late fees would be this $42 that gets assessed each month for a month that he missed.
The $42 would be 10% on the unpaid monthly amount as allowed pursuant to 243109. And that is typically what associations, in my experience as a condominium attorney, they do the 10%. So it ends up being 10%. If it's this year, it's 424, so they'll do a $42.40 late fee.
But that's not cumulative in the sense that it's not taken off the growing balance. It's a one-time hit each month. Something's not paid. 10% of what's owed is added on. So you basically, if you're not paying, you are building up 110% obligation.
Correct. Yes, that's another way to look at it. Yes, Your Honor.
And the late fees are aggregated in this affidavit. If you scroll back up or this document, go back down.
Sorry.
Right there. Stop with that box. So as of the date of this document, which I guess you said was October of this year, just last month, about $2,200 in late fees, $2,500 in interest, and that interest is calculated off of the assessment number, the 17,000, or all the stuff added together?
No, Your Honor, just the unpaid assessments. Okay.
And then there are two small numbers of miscellaneous and whatever PMC is. The big number, $5,000, that's these alliance people saying it's cost us over $5,000 to try to collect $17,000.
My understanding is that the alliance fees are monthly fees that are incurred for using alliance. They're deferred fees. But this matter has been I believe with Alliance for a number of years. And so those monthly fees and those attempts to collect has increased over time, but it's not the charge that has been incurred by Alliance. It's the amounts that their fee is charged to my client, Freedom Lofts, for their services, both pre-litigation as well as the accounting function that they're performing.
So I'll make sure I understand that. So if I live at Freedom Lofts and the McBurney account is delinquent, then your client reaches out to Alliance to say, hey, start doing your thing. McBurney hasn't paid. And Alliance, through whatever agreement they have with the COA, engages in a number of services for which they bill the COA on a monthly basis. And what we're doing here is saying the COA had to pay Alliance, I'll make it up, $80 a month, as long as they were having to work on your account, Mr. Powell. But it's been a whole bunch of months. And so it is now over $5,000 because your account has been delinquent for all those months.
That's my understanding. Though, just to clarify, I don't think that they send a bill. I think the fee is deferred, but that they do provide updates to the client saying, hey, at this point, this amount's been incurred by you as we continue this function of trying to collect the debt. My understanding, again, they're not a law firm. They're a debt collection company that specializes in HOA condo debt. So my understanding, they're doing things like phone calls, emails, letters, things of that nature to try to collect.
Okay. No fines here. In other words, the HOA or the COA never fined Mr. Powell because his condo was out of compliance or he had a dog and wasn't supposed to have a dog. This is all based on non-payment of monthly assessments.
That's my understanding. I don't, the last few times I've looked at it, I don't recall seeing any fines. My understanding is it's all annual assessments that are billed monthly.
Got it.
And then going through, you can tell that there's a history here. So going as far back as 2021, it looks like there was a balance when the statement of account was initially generated, and then you can see as we go through time, we're now in, there are some additional specially assessed amounts. There's a fire sprinkler repair. This would have been a specially assessed amount, the 384, but time's going on, unpaid amounts. And then you don't have, then you have a removal per the preem of a 384 charge. I'm not sure why it was removed, but it wasn't a payment. And then you're going through, and now you're in still no payments. And then you get to, there's still no payments. You see that the Alliance is doing work trying to collect the debt. It looks like at one point there's a collection fee adjustment. I don't know if that was a statute of limitation write-off or what, but there's a reduction, but it wasn't a payment. And then you keep going down. Okay. And I apologize. I don't know if you can see it on my screen, but I'm removing your faces so I can just look at every portion of the ledger or the statement of account. Okay, so then you see sometime early 2024, the flat fee is incurred by our firm to file the lawsuit. And you can see the costs were incurred to file the lawsuit. And then again, no payment. And then finally, in September 24, 2024, there is now a voluntary payment. So for years, there were no payments after the work from both the collection company and our office having to prosecute the case, file it, prosecute it. Now we've finally got some money in the door. And then you see now there are monthly payments, which is great. At this point, the debt's going to, let's see, the payments, for example, this payment looks like is allocated to an assessment. This payment was allocated to an assessment. So it does look like the payments are being allocated to the assessments, reducing them. This one there was a split payment. You'll see that portion of it went to it. This is the column for our fees. We returned that fee pursuant to the applicable case law. And so there's no doubt, no dispute that he's now making payments. But the reason that the payments are being made appears to be after the lawsuit had to be filed, just as that's what happened in the series of events. The Alliance tried to collect the debt through their efforts, wasn't successful. We had to file the lawsuit, and then during prosecution of the case, then they started paying their assessments. I know that there's a desire by opposing counsel, and I can understand why, to try to add in concerns related to the history for disputes as it relates to the alleged water damage or failure to maintain or repair. But again, that's a separate covenant. So to withhold money, which appears to be what happened here, because hey, I feel that you're not doing your side of the bargain for the separate covenant, so I'm not going to pay my assessments. The case law is very clear that you just can't do that. That's been the case law since the early 90s, as provided in the Force Vila case, and that appears to be exactly what happened here, where they didn't start paying their assessments until after we filed the lawsuit against them. And then at that point, there's additional amounts that became due. I don't want to go too far into, like he said, she said, whether or not someone can make a payment, because that's very clearly hearsay. We don't have the parties here to argue that, like the actual people here to say what someone said, either someone on my side, like a property manager, or on their side, the actual the Powells. But I would anticipate happen, just based on the history of this, is once they want to start making their payments, they're already in collections. And so it sounds like that the board wasn't agreeable to only pay assessments once they're now in collections, and the association's having to incur all these additional fees to try to collect the debt. So I would anticipate that's what happened. Again, though, it's difficult to say for sure because we're relying on what other people might have said.
Sure. And if it's not in affidavits or whatnot before me, then it's interesting, but it's not a basis for me to grant summary judgment, or to say, hey, there's a dispute of material fact, because it's not in the record if it's just, let me tell you what my client told me the other day. Okay. That helps me better understand some of the money flow in the case. anything you want to say, Mr. Conroy, in response to Mr. Brogdon's argument on the equity front, foreclosure being an equitable remedy and the argument that there are unclean hands, or at least there's this unresolved issue of how the place was uninhabitable during the time of the water intrusion?
Yes, Your Honor. I don't know if foreclosure is an equitable remedy here. It's provided under the Georgia Condominium Act 243109. I think it's just a remedy that's actionable. It's one of the primary means in which I've been doing HOA condominium collection law for about 12 years now, along with general representation of associations. I've never seen it being viewed as an equitable relief. It's just provided by statute. There is such thing as an equitable foreclosure action, but that's not what's being sought here. So I think that the statute trumps concerns related to equity. I know that Mr. Brogdon talked about it being apparently inequitable under the circumstances to allow for foreclosure. But again, I think statutory authority trumps equity. And so therefore, I believe that an order allowing for foreclosure is permitted. Now, from a practical standpoint, foreclosures don't happen overnight. Once a foreclosure order is granted, we still have to go through the process of scheduling a foreclosure sale, and Fulton's a very busy jurisdiction. So it's not going to be an overnight remedy, but I think that is a remedy the association is entitled to pursuant to the facts of this case.
Okay, thank you. Mr. Brogdon, anything you want to add as we wrap up the back and forth?
Yes, Your Honor, and I appreciate that. I would like to add that I believe in the notice of filing that was filed, it should be appearing on the docket that will be part of the record prior to this hearing beginning, that there will be evidence that this time period from, I believe, 2022-ish or 2023 up until September of 24, I believe there's evidence that Mr. Powell may have sent correspondence, and I think he may be online, but I don't think that would be, he's not subpoenaed, and I don't think that we're having a hearing where evidence can be presented by witnesses in this case, unless the court would oblige. But there's evidence that Mr. Powell was attempting to make payments, but he could not make those payments unless he made a full payment for the total amount which he was disputing, even if he didn't really have a legal standing or legal ground to dispute such. And so at what point is the HOA or Freedom Lofts precluded from arguing that, yeah, you've continued to incur these fees and it's beginning to rack up when you've tried to make partial payment, but we wouldn't accept it. And then finally, once there's a change in the way that they process payments, he starts making the payments again. And again, the $17,000, I believe, in the past assessments that's owed, not counting everything at the bottom as it relates to fees, because it almost doubles up. It's a little bit under 17,000. It's like what, $14,000, $15,000, I believe. That is the late fees, attorney's fees, collection fees, and things of the like. That $17,000, Mr. Powell, he can remit payment today. I think the real issue is the reasonableness of the other charges, and I believe the case site is Ballard versus Biltmore Condominium Association, and that site is court's indulgence. That site's 365 Georgia App 232, and it's a 2022 case where the attorney's fees, the Court of Appeals, they accepted the appellant's argument that the attorney's fees weren't reasonable and that was a jury question, and it was sent back down to the trial court to be resolved. So in this action, Judge, just to wrap this up, I would arguably concede that this might not be an equitable remedy because it is provided by statute, even though in its nature and how it works.
I just received a text saying we were having an audio issue here in the courtroom.
Likewise.
Yeah, and I see Honorable McBurney, Judge McBurney talking, but I can't hear him. And I can't hear Mr. McBurney. I'm sorry, Judge McBurney, because
I
yeah,
cannot. I can hear you. I can only hear you.
yeah, same. I can only hear you, sir. I did get Judge McBurney's text.
And quite frankly, I don't think there's anything else that I'm saying that's going to move the needle. I would, concede my time potentially to finish the rest of that argument.
Well,
Um,
I think there's value in having you, unless if you have something that's a deadline or something coming up where you need to get off. But I think there's value in letting everyone speak.
I'm perfectly fine with it.
Yeah, and Judge McBurney seems to enjoy it, or it finds value in having everyone talk. So I think that's a value. I don't have
Agreed.
much else to say either, to be frank.
Likewise.
I have nothing to add.
It's nice to meet you, Miss Maggie.
Nice to meet you as well, virtually.
Mr. Brogdon, and while we wait, did you go to law school at West Virginia?
No, I actually went to the University of Toledo in Ohio, but I'm from West Virginia on the Northern Panhandle.
Okay.
And so I flew into Columbus Friday, went to the Ohio State game, and then my cousin, he's a lawyer in Steubenville, we drove back to our area. And so I'm actually in his office doing this. Are you from Indiana?
No, my wife got a job opportunity at the University of Indiana, so she kind of made me move up here. So I'm originally from Georgia.
Okay.
Practiced there for a number of years before eventually moving to Indiana.
Oh, that's awesome. My uncle, was a judge here in well, not here, but in Atlanta. He went to IU for law school, and
Oh,
then well, not my law partner yet, but it's just me and him. His son just signed with IU to play baseball.
that's
So they were up
phenomenal.
there for the homecoming game for the football game.
Oh, that's phenomenal. I think I'm a Southerner through and through, but the Midwest charm is legit.
It's true.
Um,
It's true. Miss Mackey, where are you from?
I'm from Memphis,
oh,
Tennessee.
Okay.
nice.
hmm I've been here for 11 years.
Yeah, I've been in Atlanta for just almost 12.
I had a buddy, a good friend of mine, who went to the University of West Virginia's law school. So that's why I was asking about that. He's from Georgia, but he went there for law school before moving back to Georgia.
Oh, that's awesome. Yeah, I bet you enjoyed it. It's very pretty.
That's
Folks
what he
are very
said.
nice.
He said it's beautiful.
I'm partial. I'm from here. I'm down here.
Sure, sure.
All right, can you hear me?
Yes, Your Honor.
Yes,
Yes.
yes, Sean.
All right. So, unfortunately for you, Mr. Brogdon, I said, "Hey, anything you want to add as we finish this back and forth?" And you said, "I sure do." And then you spoke and spoke and spoke, and you're moving your hands, and it looked very oratorically impressive from a visual perspective. It was absolutely silent to me. So I'm like, "Hey, Mr. Conroy, can you hear me?" No, I couldn't hear me. Our unit that controls all of the audio here flows up right after you said, "Yes, I do." And so I need you to share with me again what you just shared. I know the second time is never as good as the original material, but you can view that as your dress rehearsal. But I didn't get to hear any of it. And we were madly trying to make it work. And then finally I sent that text saying, "Hey," but by then I think you had wrapped up. So sorry, Mr. Conroy and Ms. Mecca, you're going to need to listen to it again, but I didn't hear it the first time. So if you would, please.
Thank you, Judge, and I appreciate the opportunity to be reheard. Um, where I was going with the closing remarks is when we were looking at that ledger, and I think there's a factual issue, and I believe in the notice of filing, I think Mr. Brock's office is going to send the what was e-filed, I think yesterday evening, last night. They're going to send courtesy copies to everyone, including the court and opposing counsel. And I think that there's documents in there that are now a part of the record that will show correspondence between Mr. Powell and whoever the representative is as the HOA or this third party that they use for collections in his attempt to restart paying his assessment fees. But there was an issue as it relates to whether or not he could make partial payment because they were alleging or asserting their position that you need to make a full payment and we will not accept any partial payment. So at a certain point, they should be stopped or precluded from arguing that the additional fees, the additional collection costs, attorney's fees, or whatever they're arguing that is outside of the assessments that were not paid is somehow due to some, I guess, specific intent not to pay them when he was trying to pay them, right? He was trying to mitigate both sides' damages. And so I believe that will be part of the record, or is a part of the record if the clerk has approved it already, and something that will be provided courtesy copy via email. With that, Judge, the last thing I was saying is that I think Mr. Conroy is potentially correct that if the remedy provided via statute under 24.3.109, I think that was it, or 44.380, I believe, is what he cited under the code. If that is provided via statute, even though it is equitable in nature, it may be a legal remedy per statute. And so I would potentially concede that. I haven't been able to research it, but I would potentially concede that.
Okay. Tell me a little bit more about the position that somehow Mr. Powell has the ability to dictate the way the collections work, by which I mean this. He's trying to pay a little bit and the association says, we don't want dribs and drabs. You owe us, pretend it's $10,000. Pay us $10,000. Don't pay us $10,000. That's up to you. That's what you owe. And we don't want you giving us $100 a month. That's not, you pay us what you owe. Otherwise, of course, you're going to continue to owe each month for the new assessments. And if you aren't paying those, late fees will accrue. But why does the creditor not have the right to dictate the terms of payment?
Well, and that's an interesting question, Judge. From a glance, I would say they do, right? But I would add two caveats to that. One being that the payments that resumed in September of 24 weren't partial payments. They were the full assessment amounts, right? So he's not dribbling here, giving you 50 cents here, a dollar here. He's remitting the full amount of what's owed for that assessment. One, and
Okay.
then two.
If he did, let's say in August of 24, he paid $575, and that's the monthly assessment. If he wasn't charged a late fee or anything like that, then I'm confused as to what the issue is. And we saw that in the ledger. There were some months, and Mr. Conroy linked it to, we had to file a lawsuit, and that got Mr. Powell's attention, and then he started paying monthly again. He was withholding. One theory is he's withholding because of the water intrusion and the difficulties that caused him and his mother. That's not before me properly, other than I could infer it from the counterclaim. But regardless, he was withholding, and it sounds like the case law is thou shalt not withhold. It doesn't matter if the COA puts a dead body in your foyer, you don't get to withhold. That is an obligation that you've got to pay the monthly assessments. And he wasn't, and then he gets sued and he starts paying the monthly assessments, and they accepted the monthly assessments and didn't assess late fees for those months. So I'm trying to understand the part I'm missing about, well, wait, he was trying to do this and they said no.
And I misspoke about partial payments. It was the monthly assessment. So it wasn't a partial payment. He had remitted the full amount of the monthly assessment. I think what's interesting, Judge, is that the fact that it was a change in the process of how they were receiving the payments, how he could pay, because ultimately he was able to pay the monthly assessments. And there's evidence in the record now that shows he was attempting to pay those and they said no. And then ultimately they come back and they acquiesce to it, right? And I wouldn't make an accord and satisfaction argument, but it's getting to that point of saying, hey, we're now accepting this as a proper way or proper mode of payment, but we're going to sandbag you and penalize you for when you were trying to make that same monthly assessment payment, and we weren't going to accept it. And so that's one of the issues that I see arising of adding in those fees for that period of time when it was their process that wouldn't allow him to fulfill his obligation.
And the evidence that you say is in the record would be whatever was filed at midnight last night that none of us has seen before, and Mr. Conroy hasn't had a chance to object to it if it's potentially hearsay, because it could be a statement made outside of court, offered to prove the truth of the matter asserted, and we don't have the declarant here. I mean, am I fairly summarizing what you're calling is now part of the evidence in the record?
Potentially, and I would add this, Judge, that one, it might be an admission against a party opponent, being that it's a homeowners association or its representative in the representative capacity. The other is that I believe these documents, the ledgers, the correspondence was all disclosed and exchanged throughout discovery.
Okay.
And so
it's not necessarily new to Mr. Conroy. It might just be Mr. Brock is flagging it as, hey, this is part of the corpus of information that's been moving back and forth between the parties. And Judge, you ought to be aware of it as you're assessing what was going on.
Yes, Judge.
Okay. All right. Well, I will commit at a minimum to looking at what comes into the docket over the next day. Mr. Conroy, if it is something upon which I might rely, I will certainly give you an opportunity to respond. And respond doesn't mean you have to file something. It would be an email from me or Ms. Niles saying, hey, the judge received this and he thinks X, Y, and Z, and he wants to make it part of the record that he can consider in ruling on the motion for summary judgment. That would tee it up for you just via an email or whatever you want to do to say, well, here are the 3 reasons why it's not appropriate to do that, if that's going to happen. If I'm not going to consider it, you don't need to worry about it, because I've got in front of me already the record that was made for purposes of the motion for summary judgment.
I would also, yes, Ron, that all makes total sense to me. I am not sure if these documents were produced in discovery. I would ask that we, I just wasn't prepared to kind of dive into this portion of it. I don't know if it makes a difference if they did not provide in discovery. My understanding is that if it's not provided, that you can't then rely on it later. So if that's the case, if it wasn't produced, and the motion for summary judgment being filed in February, and like the court said, we're just now hearing of it today. Now, if this was something where it was produced previously in discovery, that's kind of different. I agree with Mr. Brogdon. Mr. Brogdon just came in last minute, so I commend him for being as up to speed as he is, given the last minute kind of entry. But if it's something that wasn't already produced in discovery, I would have to explore whether or not that's objectionable to be relied on now. But if it had been produced in discovery, then I'm less inclined to do so, because again, I'm not trying to win this on a technical issue only. That being said, I think another possible option would be motion for summary judgment. There sounds like there's multiple things that there's no dispute. So I think at least a partial motion granting of a partial granting would, as to obligation to pay assessments, there are unpaid assessments, all that. And then if what's left is reasonableness of some of these ancillary amounts, I think that could be done maybe through a future damages hearing, at which point, if there is documents that need to be looked at, it could be done at that time.
Right. No, and I'll tell you, that's where I was trending. If what was filed at the 11th and a half hour is something that I can consider in connection with the motion for summary judgment. It's not looking like, but I'm going to go read the cases. It's not looking like Mr. Powell's got much to stand on in terms of liability for some amount. And the question is, what is that amount? And unfortunately for him, the larger amount of the figure that is in what you shared with us seems like it is owed to the COA, because it's monthly assessments and late fees associated with those. But there may be at the edges some amounts where there ought to be a discussion about reasonableness. But to your point, Mr. Conroy, that's just the damages hearing then. I mean, it is sort of like for this word default judgment as to liability, but it's not fully liquidated. This is liquidated. There's your spreadsheet or the ledger. But the attack is a little different. It's that some of those numbers, they are what they are, but they may not be reasonable given this potential that isn't properly before me yet, but I'll look at what was filed yesterday. In fact, Mr. Powell was trying to pay, and supposedly he went to one portal and was told you can't pay in that way, and maybe he didn't know how to pay otherwise, or it wasn't made clear. And I hear that sometimes in these HOA cases, that I was trying to pay and they wouldn't take my money. I don't know that in the end that is defense. It certainly doesn't carry the day as to liability, but it might shave off some of the dollars, and not the amount owed in terms of the monthly assessment. It would be, well, how do we fairly ascribe a late fee to Mr. Powell for these 4 months where there's an email chain with Mr. Powell saying, I've got the 575 and I'm knocking on this door and that door won't open. Help me, please, Alliance or COA, and that person doesn't happen to be helpful. Not saying that happened here. That has been argued to me before, and that's sort of the tenor of what I'm hearing from Mr. Brogdon, who, as you pointed out, Mr. Conroy, is also having to drink from the fire hose as of yesterday to get up to speed on the case. So let's see what got filed, and then I'll reach out to both sides saying, I'm not considering it and here's why, or I think I should consider it. Mr. Conroy, please respond to see if you disagree. But I suspect in the end, the result of considering it would be an order that grants summary judgment to Freedom Lofts as to liability, and probably as to a big chunk of that money, but maybe not all of it. And we need to have a hearing in the future about, well, what do we do for these 7 months that seem to be ones where Powell was trying to pay and the money didn't go through, or who knows what. But I don't know, because I haven't seen any of those materials. And it sounds like, Mr. Conroy, you may not have either if they weren't produced in discovery. So everyone needs to absorb what was filed.
And Your Honor, just a small clarification, something you said earlier, because I absolutely believe in candor to the court. It looks like some of the more recent payments, if I can just very quickly share my screen. You had said that no late fees were charged when there was a payment recently, and I'm paraphrasing heavily, but it does look like there were late fees added after the payment. So if the court had a view that late fees being charged when there was a payment for purportedly that month, though I anticipate maybe these payments went towards the older debt, and so the newer assessment still was unpaid if the payment's going to the older unpaid assessments, which is typical standard practice for accounting. But I just wanted to make sure that the court was aware that there were late fees.
Okay.
Because you had said there wasn't. I just want to make sure there wasn't an appearance of me trying to deceive the court.
No. I appreciate that. The ledger has what it says. I mean, I didn't hear you say there were no late fees. I heard you say and point to, look, we filed the lawsuit and now magically 575 coming in each month. And I took that to be not just, hey, this is what I choose to pay this month, but I better at least pay my monthlies, and I'll duke it out with the COA about this historical balance that I've got, but I'll at least try to stay current with what's coming in the door. But maybe for accounting reasons, the COA is not obligated to apply it to the current, which is tough for someone with that size arrearage, because then he's basically paying 110% every month until he pays down that big old balance. But I guess that's a way to motivate someone to pay down the balance.
Yes, Your Honor.
Okay. Mr. Brogdon, was there something you wanted to add?
No, Your Honor. Thank you. I hope you all have a great Thanksgiving holiday.
Well, I do want you to add one thing then. What are we doing with Crabapple? Before you were involved, your predecessor said, wait, we need to add this other party, judge, do this, do that. I entered an order and nothing has happened. So I want to know what you understand the defense approach to be in terms of this party that we added. So let me make sure I'm not speaking out of turn.
Yeah, because I want to make sure, Judge, if I'm hearing you correctly, it's the court's position that there was either a consent motion or a unilateral motion seeking leave to add a party defendant or a third party defendant. And this court has granted that order, but this party has not been properly served with process.
I think that's right. So I'm looking February 24th. So 8 months ago, almost to the day, I entered an order at your client's motion to add a cross-claim defendant. And that's the right structure of this because the Powells are saying, Crabapple, you messed up our roof. And so I granted it, that pulled it off a trial calendar. They're supposed to be served and they weren't. And so we don't have an answer from Crabapple. And it's not the Freedom Lofts job to serve them. So hence my question. And you may need to reach out to Mr. Brock. I'm unclear as to who's doing what for the Powells.
I'll say this, Judge, we will get them served with as soon as possible. I've just gotten into the case. Now that I know that framework, I will go ahead and confer with counsel after this hearing is adjourned, and we will make sure that we get process out to a sheriff or a private process server so that they can be served.
Okay. I mean, confer with counsel. I'm not saying you have to do that. You may look at this and with a fresh set of eyes say, we're not going to pursue that. One way or the other, we need either activity, i.e. they're served, or notification that, you know what, that's not the approach we're taking anymore. We've brought additional representation on board and we want to restyle the case back to the way it was, which is Freedom Lofts versus Powells. And we don't need Crabapple in the mix. One or the other needs to happen before the year is out so that this is a 24 case and we're going to be in 26 still dealing with it. And it's not a super complicated case. So it is time to make sure it moves along. So please do keep us posted on that, Mr. Brogdon.
Yes, Your Honor.
All right. Anything else, Mr. Conroy?
No, Your Honor. Thank you for your time today.
You bet. Ms. Mecki, anything from Drew Goal?
No, Your Honor, not today. Thank you.
All right. Well, happy Thanksgiving to everyone all across the country, Indiana, West Virginia, Georgia. Enjoy it. Stay warm and dry.
Thank you, Your Honor.
Thank
All
you.
right, bye-bye.